I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I am bringing you compilation number 231. We will be in 3 different judges' courtrooms for this compilation. Before I give you their names, don't forget to like, comment, share, and subscribe. Also, commentary will be left in where these proceedings had commentary at previously. Also, chapters will be added for your convenience. Now, the 3 courtrooms we will be in on today, for the first time, we will be in the courtroom of Judge Thomas Dries, and shout out to Sovereign Citizen Chronicles for sharing this video with me, this proceeding. Second, we will be in the courtroom of Judge Chad Crum out of the state of Kansas as well. And last but not least, we will be in the courtroom of Judge Jessica Hammond out of the state of Michigan. As always, it is a pleasure to bring you these compilations. And now let's go ahead and jump into 231.
Okay, how's everybody? Good
Okay,
morning.
this is in the District Court of Gove County, Kansas, case number 25 TR 687, State of Kansas versus Francis F. Hodge. And you are Francis Hodge?
Yes, the living man, Francis Hodge.
Okay. May I have an announcement of appearances, please?
I'm sorry.
May it please the court, the state appears by Noah Haas, Assistant Gove County Attorney.
And you're Francis Hodge the third?
Yes, the living man.
Okay. And Mr. Hodge, it's your desire to continue representing yourself,
Yes, sir.
and you're not requesting counsel?
Correct.
Okay.
Well, I mean, the counsel I have is just not a lawyer. That's all.
Okay. And you do understand the potential punishment for these offenses?
I do.
Okay.
According to your ways, yes.
Okay. By statute, count 2 and count 3, for which you're entitled to a jury, if convicted, you could do up to 6 months in county jail and up to $1,000 fine.
Yeah, that's your statutes. Yeah.
Count 1 is an infraction, a speeding infraction. That's tried to the court, not to the jury. Okay.
Okay.
And that is subject to a fine if convicted.
Okay.
Okay. Now you've requested a jury, and we've got a jury trial scheduled for Monday, June 29th, in 2 weeks.
Correct.
Okay, and you understand you have to be here in person in
Correct.
the Gove County Courthouse.
Yes.
Okay. Currently, count 1 is charged speeding 75 and a 70. That's a traffic infraction. Count 2 is failure to provide proof of insurance, a Class B non-person misdemeanor. And count 3 is driving while revoked, a Class B non-person misdemeanor.
Okay.
Mr. Haas, are there any amendments to the complaint or information? I noticed you had filed an amended complaint on June 12th, 2026. It cites the exact same charges. You've just put it into a little different statutory language.
Clarified the subsections, Your Honor.
Have you sent that to Mr. Hodge?
Yes, Your Honor, we did by mail.
Okay.
And I think email too.
Have you received that, Mr. Hodge?
I received it by mail. Yes.
Okay. So you're fully aware of what you're charged with, and you're not looking to amend those charges any further, Mr. Haas?
No, Your Honor.
Okay. And Mr. Haas, have you issued your subpoenas to assure the attendance of your witness?
I don't think I've done that yet, Your Honor. I have spoken with the officer. He's aware of the date. I can get that in. I can get that done today.
Okay. I'm sure you get that done.
Excuse me, Judge, and Mr. Prosecutor. Could I get your full names? I do apologize.
Yeah,
My full name is Noah Haas.
Noah Haas. Noah, Noah,
Yep.
and Haas, Haas.
Hahs. It should be spelled out on the Zoom there too.
Okay. I'm sorry, what was it? I got two screens up. HA, what?
H as in house. So there's two H's as in
Okay.
house.
HAHS.
S.
Okay, gotcha. And are you bonded as well? Mr. Haas?
Mr. Hodge, that's not an appropriate question at this time. Okay.
What do you mean at this time? What time will it be appropriate?
Well, he is a duly appointed assistant county attorney.
No, I understand that, and every attorney needs to be bonded just like you as a judge.
He's licensed.
No, I said bonded. I didn't ask for a license. I asked if you guys were bonded.
Well, he's
Um,
licensed. He's sworn in.
are you required by Kansas statute to be bonded to perform your duties as judicial officers,
We're required to be licensed. We're
but
required
not bonded?
to be elected and or appointed.
But not bonded is what you're saying? You're not
Right.
required to be bonded?
Right.
Okay.
Okay.
And what was your full name again, Judge? I'm sorry.
Just like it says on the screen, Thomas J. Dries.
Yeah, I'm on two screens, unfortunately, on the Zoom, and I can't see that part. I'm typing on my notepad
Okay.
here. Can I go ahead and get your name for the record?
Yeah, Thomas J. Dries. Okay. Mr.
I think
Hodge, have you sought discovery and inspection in this matter?
I'm sorry, how about what?
Have you sought discovery and inspection?
Have I sought discovery? Yeah, I'll present everything at trial.
No. Have you
I,
sought discovery from the state?
oh, have I sought discovery? No, I don't see a point to seek it because it's already presented.
Mr. Haas, have you sent any discovery to the defendant?
Your Honor, we have not received any requests for discovery, nor have we sent any discovery materials.
Okay. And have you requested reciprocal discovery?
No, Your Honor.
Mr. Hodge, do you intend to set forth any objection to the institution of the prosecution?
Oh, of course, I do have objections, but um, being that we already have the trial date already uh, uh, in place, it wouldn't do any good to try to do anything before the trial because we're not going to get anywhere.
Okay. So you're not alleging any defects in the complaint?
I'm sorry. What is that in like plain English? Any defects and complaints? Are you saying, do I disagree with any of the charges?
No, I'm saying, are you alleging that they have charged the wrong crime? Have they charged the wrong date? Have they charged the wrong jurisdiction?
Oh, the wrong crime for sure. Jurisdiction, I'm still up in the air. I'm not sure about, but yes, the wrong crime. Yes.
Okay, you don't believe you were in Gove County?
Oh, I didn't say that. I got pulled over in Gulf County, so we know I was in Gulf County.
Okay. Are you claiming any violation to your right to speedy trial?
No, I think this is speedy. I have no complaints against that part.
Are you claiming any alibi?
There's no alibi to be had.
Okay. Are you intending to file any motions to suppress during the trial?
I won't know that until the trial.
Okay, the trial is set for June 29th. It is one day. It is a 6-person jury. Each side has 3 peremptory challenges. So we will qualify 12 jurors and strike down to 6. Okay. And does either party anticipate filing any motions in limine?
And what?
Motions in limine, which is,
Okay.
that's
Yeah.
a motion to limit what can be presented.
Oh, no.
Yes, Your Honor, I do intend to file a motion in limine
Concerning,
concerning anticipated meritless legal arguments.
What does that mean?
such as what?
Arguments that Kansas lacks jurisdiction over the defendant, uh, arguments about being a secured party, traveling, not driving, jury nullification, arguments about the judge, the court, or the state being corporations, claims that statutes only apply upon consent of the defendant.
Why would you limit that?
How long do you anticipate needing to get that on file, Mr. Haas?
Believe I could get it filed within the next couple days, Your Honor.
Okay. Can you do it by the end of the week?
Yes, Your Honor.
Okay.
Would that filing be ruled as okay to have those limits?
We'll take that up at the time of at the start of the trial. We'll take
Okay,
those
because
up.
I would need to know that before the trial. Because if those kind of limits are there, then basically it sounds like you guys would be violating my constitutional and civil rights if it's accepted.
Well, we'll take those up at 8:30 in the morning on the 29th.
Well, a part of me showing up, I could take a warrant, but I think it would be more fair if that is known ahead of time, because there won't be no sense in me playing those kind of games if I'm unable to bring the fullness of what I may bring, what I have to bring, representing myself to the table. There shouldn't be no limits. You should be able to hear everything, especially when it comes to the law.
Well, he's filing his motion by Friday
Mhm.
at noon.
So should I file a motion to have no limiting?
If you wish to file a response, you must file that by next Wednesday at
Okay.
noon.
All right.
I'll make sure I email you immediately after filing, so you should have enough time. As well as we'll mail it out too.
Okay. And can I also get your email so I can file as well?
Yep. I have sent you some correspondences, so you might be able to find it, but it's Noah. That's Noah.
Okay. Now I'm talking about to the judge. You said you was gonna
Oh,
email the judge.
I'm going to email you the motion right after it's filed, so you have as much time as possible.
Okay, I appreciate that. But I would also like to file my motion to the judge just like you. I
Well,
just need an email if that's okay.
You'd file it with the court.
Okay, and what's the court's email?
So Judge, he can't file by email with the courts. He's a pro se litigant. He's going to have to either fax it to the Gove County clerk, or he's going to have to mail it. We
Yeah.
can't take an
Okay,
email filing.
You'll have to
Okay,
fax
that's
it then.
fine. Yeah, and can I get the fax number?
It's 785
785
938
938
2312.
2312.
That's correct.
Okay, thank you very much. I appreciate it.
You're welcome.
And you need that motion in by next Wednesday, you said?
Yeah,
Or-
by noon on the 24th.
Okay.
Sandy, could we set up a Zoom hearing on the 25th?
Okay, let me look. For like a review of this.
On the motion in limine?
Yeah, June 25th.
Yeah,
We sure can. You've got time. What works for you, Noah?
Give me just a moment here.
And what is that called again? A motion of limity?
motion in limine.
Oh, in limity. Okay, thank you.
Limine.
Limine. Okay, got it. Thank you.
I could do most of that day, Your Honor. I do have a Zoom hearing at 3. The earlier morning would work best for me.
We can do morning. We can do you want to do a 10 o'clock? Mid-morning?
10 o'clock works.
Okay.
Okay, all these extra steps is interfering with my work. So how can we limit some of these steps so I can stop missing work? Or can I just charge my time from work off to the courts?
Well, you can't charge your time to the courts, but Mr. Haas will file the motion in limine. You'll have a chance to respond to it. You want a hearing prior to trial, so at your request, we're setting a Zoom hearing at 10 o'clock Friday or Thursday, the 25th.
I didn't request anything before the trial. I just asked
You're
about the motion.
requesting the court to rule on the motion prior to trial.
Okay. Oh, that's what you're saying. Okay.
That's what you just
And that
requested.
means right. And I have to miss work for this small period of time for that, is what you're saying?
Yes, you'll need to appear at that hearing because you've requested the hearing on the motion in limine. So we'll
Okay.
have that on the 25th at 10 o'clock.
Okay. Yeah, I got you. I just wanted to be clear. I want to
Okay?
make you have an understanding.
And
Appreciate it. Thank you.
then you'll be here for the trial on the 29th. Okay?
Okay.
Are there any questions of law that either party think will arise during the trial?
I think Mr. Haas and I, we already had such a discussion and it led to nowhere. So I have that's the only reason for the motion in limine form on my end.
Okay. Mr. Haas?
Your Honor, the anticipation of any matters of law has already been outlined in my request for the motion in limine. I don't see unless without defendant letting us know now, I don't anticipate anything that I haven't already mentioned.
Okay,
And also too, I don't know anything vice versa. You haven't let me not know anything either, so we're both in the same boat.
I suppose, Your Honor, that I do have a motion. If it's filed too late and we're not going to hear it, that's fine. But I suppose that's an additional issue of law that's pending.
what is that?
So I did file a motion to reconsider for bench trial. I do believe the law supports that. You
What
did make
law?
a ruling on it already, but it was based on the lack of a written request for jury trial on the defendant. And I mean, I kind of lay it all out in the motion, but
But the judge granted it.
Yeah, the
He said there
purpose,
was no need. I didn't need
hang,
to.
hang on, Mr. Hodge. Let me speak.
Yes.
The purpose and requirement of that, Mr. Haas, is so that he doesn't show up at a time of a bench trial and say, hey, I want a jury trial. So you have to make your request. He made his request to the court in person, which is as good as filing it in writing. So the court heard his request for jury, and he's entitled to a jury on counts 2 and 3. So
I'm happy. I'm okay with that, Your Honor. I disagree, but I'm 100% okay with your ruling. I object. It's all in the motion.
that's fine. And you've got your objection noted for the record. And if at an appropriate time you wish to take that up with the Court of Appeals, you can do that. Okay?
Gotcha, Your Honor.
Okay. So exhibits, the state, your exhibits will be using numbers, 1, 2, 3, etc. The defendant, Mr. Hodge, if you have any exhibits you're going to file, they must be filed using letters. Exhibit A, Exhibit B, Exhibit C, etc. Okay?
Write that down as well.
Is there any
Okay.
technology or media anticipated at trial by the parties?
Um, Possibly, but it depends on me presenting the exhibits, which I will have photocopies of for everyone.
Your Honor, I do anticipate showing video.
Okay. You must work with the clerk to make sure that you have the appropriate technology in the courtroom and available.
Yes,
Okay?
Your Honor.
Okay. Test it out, make sure it works.
And when you say appropriate, what does that mean exactly? Like if it's on my phone, I need to have that connection or that Bluetooth or Wi-Fi or something connection with the courts.
Well, if it's on your phone, that's a bad thing because then your phone will be taken into evidence. If you're going to admit something, you need to put it on a medium that can
Oh,
be
like a drive.
trial. Yes, like a drive.
Okay.
Okay.
All right. Thank you. Yes. Yes, Your
Okay.
Honor.
Do either party anticipate any issues with the jury instructions?
No, Your Honor.
I don't know what the instructions are.
Okay.
Can I get that in writing and mailed to me?
Well, it's your obligation to provide any proposed jury instructions you wish to have to the court. Those are the pattern instructions of Kansas.
And I could get those through the clerk's office there.
Well, you'll have to get it online. I mean, you certainly can come into the clerk's office and look at them, but it's a
Okay.
large volume and they're not going to copy it for you.
Okay. And you said online, where do I go to get
Just
that?
look up pattern instructions of Kansas through the Kansas Judicial Council. Any proposed instruction should be cited by number. If you have any requested changes, you must cite them by producing the instruction with the cited change. And Mr. Haas, on your element instruction for counts 2 and 3, make sure you go ahead and submit your element instructions because there are options you have to choose. Okay? And
Yes,
Okay,
Your
my
Honor.
charges were what exactly again? Speeding.
the speeding is tried to the court, so you don't have to worry about the speeding.
Okay,
The
but
two that are tried to the jury are
mhm,
no proof of liability insurance.
okay,
That's count 2, and count 3, that you were driving when you were revoked.
okay. All right, thank you very much. And that's count 3.
That is count 3. And Mr. Haas, on your amended complaint, you're still indicating canceled, suspended, or revoked. It's not in the alternative. Which one is it?
Suspended, Your Honor.
Was he suspended versus revoked?
I believe so, Your Honor. I'm not 100% certain.
Well, you'll need to, at the time of trial, will then narrow it down to whether it is suspended or revoked. That is not an alternative charge.
Yes, Your Honor.
Okay. So any proposed instructions the parties wish to submit to the court must be submitted by June 19th at noon.
Okay,
Again, if you're just requesting an instruction as it is printed in PIC, you just have to give us the number of the PIC instruction. And Mr. Haas, on your element, go ahead and prepare your element instructions for counts 2 and 3. And
Yes, Your
submit.
Honor.
Okay. So the parties need to be in Gove County at the courthouse on the 29th by 8:30 in the morning. Okay?
yes, Your Honor.
Okay, I have prepared the pretrial order, and we'll file that and send it to the parties.
Thank you, Your Honor.
Anything else we can take up today?
Yes, Your Honor. Um, so our office has a legal intern admitted to practice under Rule 715. I do intend on having him as co-counsel, and according to that rule, I do believe I need approval of the court. So I'm just asking for that approval.
Yes, he can appear with you and sit at your table, and he can act accordingly at the trial under your direct supervision.
Thank you, Your Honor.
Okay. Okay. Get your motion in limine filed and your jury instruction filed, Mr. Haas. Mr. Hodge, make sure you respond by next Wednesday at noon.
The 25th by noon.
No, you have to respond on the 24th by noon.
Oh, 24th by noon. Oh, I'm sorry.
We'll
Yep,
have a
24th.
hearing on the 25th at 10 a.m.
Right. No, I have that. I apologize.
Okay?
Yep. Yes, sir. Appreciate
Okay.
it. Mhm.
Thank you all.
All right. Thank you as well.
Good afternoon. Your name, sir?
David Walker.
Your Honor, it looks like he has two files.
I see that. All right, we'll next take up two cases, both entitled State of Kansas versus David Wayne Walker, 22 CR 398 and 22 CR 508. All right, we'll first take up 22 CR 508. This is my case, Mr. Walker. You failed to appear in front of me on July 17th for your preliminary hearing control docket. Where were you that day?
It's safe for sure, sir.
Okay, well, I issued a bench warrant bond forfeiture and set a new bond in the amount of $10,000 cash or surety. Are you still representing yourself?
Yes, sir.
You want to continue representing yourself?
Look at me. I'm not looking at you. I'm looking at the paper. Yes, sir. Don't have any money to.
Pardon?
Yes, I guess I represent myself.
Okay, you understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
Okay, well, he could provide you legal advice and perhaps advance any defenses you may have had, but if you want to represent yourself, you have that right. I just want to make sure you understand that if you can't afford an attorney and would like to have one represented you, I would appoint one for you. Do you understand that?
Yes, sir.
And you wish to continue representing yourself?
Yes, sir.
The docket notes don't reflect if a waiver of counsel was ever signed. Do you have any notes that would reflect that he's waived counsel on the record or otherwise, Ms. Norris?
Your Honor, I just note that on December 30th of 2022, defendant stated that he would hire his own counsel, and then he had a failure to appear. And on May 5th, we did not appoint any counsel. I don't show an actual waiver. And the notes don't reflect that he did a waiver on the record. It just says that he would hire his own attorney.
Okay, well,
Okay.
Mr. Walker, you've indicated here on the record that you wish to waive your right to an attorney and represent yourself. So I'm going to have you, if the jail has one, sign a waiver of counsel. Do you have a form?
I believe so.
All right, can you read through that? Make sure you understand it. If you have any questions, be sure to ask me.
There's
Yeah.
no defendant in the, and I'm the defendant in the case. Am I the defendant in the case? There's no victim. There's no victim to my crime, correct? The crime that I'm accused of, there is no victim in the crime.
The state of Kansas, you have drug charges, possession of methamphetamine, possession of paraphernalia, and driving while suspended are your three charges.
Yeah, but no victim, correct? No victim in the crime. No victim.
I'm not sure I understand your question and what that has to do with your waiver of counsel.
Well, I'm the defendant. There must be someone making a claim
The state of Kansas is making the charges against you, Mr. Walker.
the state of Kansas is the victim.
The state of Kansas charged you with these crimes. Do you wish to represent yourself or do you wish to have an attorney representing you?
I will represent myself.
You've got a waiver of counsel in front of you, correct?
Yes, I suppose so. Why do I need to sign? Why do I need to sign it? Why do I need to sign this?
Because I like to have it documented in the file that you understand that you have a right to have an attorney representing you. And that if you can't afford to hire one, one would be appointed for you. And you understand that, and knowing those rights, you wish to represent yourself. That just documents that for the court file.
What I don't understand is why there is charges against me when there is no victim.
All right, Mr. Walker, I'm not going to play this game this afternoon. I'm going to set this case
Why are we playing a game?
in front of me on
I'm asking questions. I'm really asking questions.
October.
Trying to understand.
Mr. Walker, your case is being set on October 10th at 2:30 in front of myself. And that will be done by Zoom. That's the felony preliminary hearing control docket, October 10th at 2:30.
Your Honor.
You got a $10,000 cash or surety bond on that case.
Yeah. I was wondering if I wouldn't be able to have access to certain legal things to be able to put my case up.
I believe they've got a law library there at the jail. I'm not sure what kind of access they provide to you, but you can consult with somebody there at the jail.
Okay.
All right, I'm now going to take up 22 CR 398. This is Judge Webster's case. Looks like you failed to appear in front of her on July 31st. She set a new bond for $6,000 cash or surety. You've already had a first appearance, so I'm going to set this in front of Judge Webster on October 30th at 9 o'clock in the morning. That will be by Zoom, October 30th at 9 o'clock in the morning. So again, your bond is $6,000 cash or surety. Anything else on this case, Ms. Norris?
No, Your Honor, thank you.
Your Honor, was the time for court on October 10th for 22 CR 508, was that 2:30?
That's correct.
Just clarifying. Thank you, Your Honor.
All right, we'll be in recess. Mr. Walker, you are excused. Thank you.
All right, and so this is case number 25T01947FY, people of the state of Michigan versus Robert Wayne Sigsby. And counsel, you can place your appearance on the record.
Good afternoon, Your Honor. Mitchell Young for the people.
And Mr. Sigsby, you can state your name, please.
Robert Wayne Sigsby.
All right.
Yeah.
And
Executor, beneficiary, kind of formal.
all right. And we are here today on a probable cause conference. We had a hearing on July 31st. At that point, Mr. Sigsby had stated that he was wanted to represent himself. We had a long conversation about that at that time. And I did determine that Mr. Sigsby would be permitted to represent himself and that Attorney Hilliker would no longer be appointed on the case to represent Mr. Sigsby. And so then at that time, Mr. Sigsby, you stated that there was some more discovery that you were looking for, body cams and some other things. And so we adjourned to today's date. And then we find ourselves here today. So on that note, Mr. Sigsby, do you have all the discovery that you were looking for?
I do not. I wanted to confer with the prosecutor and I had more paperwork to turn in and I worked tirelessly to get the paperwork in. I got it in. There was no more overnight mailing. So I got it in on Tuesday I don't know if the prosecutor, David Layton, had received the add-on to the paperwork. I see this prosecutor here has zero paperwork in front of him. So he didn't even get the first paperwork or all of it was sent in. I don't know, Mr. Prosecutor, did you receive any paperwork?
I think they do everything they have a system called Carpel where they do everything digitally. So if he does have a digital file with your paperwork in it, probably would be
looked like
digitally,
this.
I believe, Attorney Young.
Your Honor, I'm unaware of anything that was given to our office. My understanding is that Attorney Hilliker provided all the discovery that we gave to him to Mr. Sigsby, and from there he has everything that we have at this time. We did provide Attorney Hilliker the body cam of Officer Isaiah Voorhees, and that is all I have in regards to body worn camera at this time.
But
Yeah, I want to be respectful.
thank you.
So what I said in the last PCC, seeing as how we don't have a Fifth Amendment indictment here, we're going through this process. I feel it's very constitutional not to have an indictment. There was supposed to be body cameras from the other officers, roughly between 9 and 12. I could hardly count how many police were there because of what has happened on the side of the road. It would exonerate me if I had different views of the behavior and the actions of the arresting officer in this civil infraction.
All right, so
The fruit of the poisonous tree has been definitely happened.
Your Honor, if I may, I'm obviously not an expert on the facts of this case as I'm just covering today, but my understanding is that the body cam of the arresting officer was provided, being Isaiah Voorhees.
If I may.
okay, well, hold on, let me ask a question. So on that one body camera of the arresting officer, do you have that, Mr. Sigsby?
I do.
Okay,
And
so
what-
you have the one, it's just the other ones that you
Right.
want. Okay.
Exactly, because what the deputy did is he concealed he put his body camera on this side of me and blocked it while he reached into my bag and into my pockets. I was cuffed. And he reached in the pocket. I looked down and seen him pull out my Native American herb. And then he stuffed it back in my pocket, but I thought he took it with everything else and threw it into the vehicle. So that right there would exonerate me that I did not bring nothing into the jails. He did.
No malice.
Okay, nope. Mr. Renfro, you don't have any standing to talk, so I'm gonna let you stand there, but that is all I'm gonna let you do. You can't say any words today.
I am appearing next, Brent.
You are not, because that is not permitted by the Michigan court rules. You can stand there, like I said, I'll let you do, but if you keep talking, I'm gonna make you sit down, and then if you don't follow those rules, I'm gonna have those nice gentlemen back there escort you out of the room,
Thank you.
okay? So, remember, my rules, my court, it's just how it works. Okay.
Objection. I'd like to have an objection.
Sure.
The definition of court here is the person in suit of the sovereign, the place where the sovereign sojourns with his regal retinue. This is my retinue. Blackwell's dictionary is cognizable by the Congress.
All right, this is the 67th District Court. I'm the judge of the 67th District Court, and that's all I'm gonna say about that. Okay, so whatever that objection is, it's overruled. Okay, let's get back to the issue at hand, though. The issue at hand is that Mr. Sigsby would like some additional body camera footage. Attorney Young, I know that you weren't here last time on this case, right? It was a different, I think it was Attorney Crummer, I think.
I believe so, Your Honor.
All right.
It's either him or Attorney Pokrakis.
So here is what I'm going to say today, what I'm going to order today is I do think that it is relevant, and I think that it is pertinent if there are other body cameras available of officers that were there on scene, then I do believe those need to be turned over to Mr. Sigsby because I do find them to be relevant. And I think that it's not unreasonable to want those things prior to the preliminary examination. So I am going to order that those be turned over. I'm also going to state though that the discovery is what the discovery is. And so sometimes there are situations where people think there is additional discovery that does not exist. So if there is 5 body cameras, then there's 5 body cameras. And if that's what the prosecutor's office says that that's all they have, then that's all they have. So we're gonna order that everything the prosecutor's office has needs to be turned over. If there are additional body camera, they need to get that and they need to turn that over. But we're not going to continue to have a conversation over and over again about discovery that needs to be, or that discovery that Mr. Sigby you think might exist that doesn't exist. So when we come back next time, I'm going to expect the prosecutor's office to turn over everything they have, and then we will move on to the preliminary examination phase, because we got to start moving this case along at some point.
So Michigan,
Hold on one second. Attorney Young, how long do you think it will take your office to get that additional information for Mr. Sigby?
Seeing that this is the Genesee County Sheriff's Office, I should be able to get it relatively quickly. However, the videos would need to be reviewed prior to release. I'm thinking 2 weeks would be more than enough time. I could probably do it if I'm lucky by the end of this week, really, to get them. So I'll leave it to the court and I'll get it done. But I'd say either a week or 2.
Right.
Mr.
Mr. Sigby?
so the problem I have is, a couple of them, is one, Michigan State Constitution says I get to confer with the prosecuting office. I'd like to do that.
Sure.
And then another thing is, on a scene such as that one, you'd think every one of these cops would have, police officers would have their body cameras running. So if he wants to look at them ahead of time and said there is none, no evidence, I'd say that was conspiracy against my rights at that time under United States Code 18 U.S.C. 41.
But we're not even there yet.
I get it. I get it.
So,
But okay, the video I got, there's a chunk in there where he says if this man would have been by himself, I would have, and it went blank. You can see the lips moving, but you can't hear nothing. So the editing process is taking away exculpatory evidence.
those are things, so
If he
Those
threatened me
things-
with death,
those are the things, whatever happened, those are the things that get brought up in front of the jury. You can bring them up in front of your preliminary examination as well, but they get brought up in front of the jury to show weight of evidence. If you're claiming there's evidence that's missing and things like that, those things absolutely can be brought up. It's just that we're not going to prevent having a preliminary examination by saying that you think that there's evidence out there that they're saying that they don't have. Do you see what I'm saying? So once they say, this is all we have, these are all the cameras, then we are going to have the preliminary examination. That's all I'm saying. So we're going to give you time to do that though, and give you time to talk to the prosecutor's office once you have that information. All right. So having said that, let's pick a date for the next court date. I think Attorney Young, you're right. I think to get the information to Mr. Sigby and then give Mr. Sigby and the prosecutor's office, everybody time to review everything, and then give the parties time to talk if they want to. I think that setting this for one more probable cause conference, I will find good cause to do so. I do think that's a good idea. And I'm looking at September 4th. Does that sound like a good day to everyone?
well, I'd like to get 21 days so I could send the prosecutor a proper notice of non-response.
That is appropriate.
Oh, you got good math.
Do you want, I can give you a little bit, we can put it on the 11th.
Well,
if you want. I can give
I
you a
would
little
like it on the 11th. The reason being because I'm going to send a bill of particulars. If this county does not recognize Fifth Amendment indictment, then they're going to have the bill of particulars, because without that, the substantive due process has been violated on its face. There is no indictment on this felony charges, and it is the fruit of the poisonous tree. So I'm concerned that the Constitution of the United States is not being followed on its face by all
Yeah.
parties.
Here's
It's a
what-
point of order.
So
Point of order is a real, what, I got to get it out of the law book again?
I've looked at Mr. Sigby, I've looked at everything that you filed. In fact, not only have I looked at it, I've highlighted it, and I've even made my own notes.
I see you.
So please know that I do read everything that's put in front of me and
That's
I
blessed.
take it seriously.
Thank you.
But a lot of what you filed is not relevant nor pertinent nor accurate law in any way. And a lot of it too, it's not filed properly in the sense of this. You have to file it as a motion. So if you do have a motion, we'll hear your motion at the next court hearing, okay? But it has to be filed as a motion. For example, some of these things like judicial notice of adjudicative facts, notice and demand to cease and desist inland piracy.
I'm not an attorney.
Hold on. I'll let you say it when I'm done. It's nonsense. It's nonsense and I'm not gonna address it. Notice of document filing, things, affidavit of truth. One thing I did want to point out to you, you filed your birth certificate in this file. This is a public file. So people could go and get a copy of your birth certificate because it's right here in this paperwork. I would have not done that. I'm not giving you legal advice in any way, but that just doesn't seem like that's a good idea. I just wanted to point that out to you because when I saw that, I thought, that's not. I also have this appearance of next friend and these things they're just not.
There's Supreme Court.
Hold on, stop. I'm gonna let you say those things in just a second. They're not permitted under the Michigan court rules. There's no statute that permits things like this to be filed, and frankly, there's not going to be. I'm not going to spend a lot of time addressing them because they're not relevant to these hearings in any way. I just wanted to let you know that.
I object on the record, be reserved on the record to correct the record. The supremacy clause of the United States does bind you to all of this. Article 6, clause 2, you're in breach of that clause for saying Michigan does not recognize these. You guys are foreign citizens. Title 28, 22, United States Code, Foreign Relationships and Intercourse. Chapter 11 identifies all public officials as foreign agents. Federal Rules of Civil Procedures 4J states that all courts, jurisdictions, and immunities fall under foreign state. 22 CFR 92.12-13 Foreign Relationships state an oath is required to take office. The 11th Amendment, foreign citizens cannot invoke the judicial powers of the state. 28 USC 3002-15-8 defines the United States means a federal corporation. Michigan is a franchise, and so is this subdivision is a franchise of a federal corporation. Corporations have no parity with the tangible in Howard versus Dolan's administration. Governmental actors are foreclosed from creating and attaining parity with the tangible. These are res judicata, Supreme Court laws of the land. Now, I'd say that was treason on its face. The judge has just committed. Well, I'm a living man.
Stop. I'm talking now. I've been accused of committing treason before, not committing treason. Everything you just said is nonsense and it is not applicable in this court. We're going to leave it at that. We have a court date now set for September 11th, 2025 at 11 o'clock a.m. That will be a probable cause conference. We will be, hold on, let me see where we'll be. We will be back here in Burton on that day. So we'll be here in Burton. For probable cause conference. Any motions that anyone wants to file, try to get filed by that time, though I'm not doing motion cutoff or anything of that nature, but it'd be a good time for us to discuss those things. We're not going to discuss any of this again because I have addressed it and found it to be irrelevant to this criminal case today. And anything else from anybody?
I do.
Yes, Your Honor. Just briefly, as is our typical office policy with pro per defendants, I will, once I have the body cam for Mr. Sigby, I'll have it on a flash drive and I'll hand deliver it to him in court at the next court date. It seems to be the best way to give that discovery. Unless there's another idea.
Can he pick it up at like a clerk's office or something like that?
I don't see why not.
The problem is that we're gonna adjourn it out almost a month. And
Yeah, I don't see why
we're gonna have
not.
to adjourn it again for him to review it, so I don't like bad idea.
And I guess I just don't know how I would. Well, I think Mr. Hilliker gave us his address. I don't know how I would be able to contact.
Mr. Sigby, what's your opinion on that?
Well, yeah, I don't want no improper service here, Michigan. Michigan,
Let's
If there's
see
gonna
what
be an
we're on
issue
at.
with
How do you
service.
want it? How do you want it provided to you?
I will meet up with him at the conference. I'd like to have a conference with the prosecutor.
Well, you're
Well,
gonna
it says so.
schedule
It says so in
that.
Michigan State Constitution. Let me pull up paperwork.
No.
They just-
No, stop. All we're talking about, I'm not talking about conferences right now. I'm just talking about getting discovery to people. So if the prosecutor's office, you know what? No, we'll do it this way. It's the only other thing we can do is I'm going to move the PCC. We're gonna have a PCC on August 28th, 2025 at 11:00 a.m. That will be to exchange discovery. Okay. So that way we can do it here in the courtroom. There won't be any questions about it. I don't want to put any staff member in a precarious position being accused of things that not delivering things or something along those lines. I don't want to put anybody in that position. So we'll just come back here on August 28th, 2025, 11:00 a.m. We'll have a very brief probable cause conference, and that will only be to exchange discovery. If there are any other issues in regards to discovery, we can talk about them too. And then we'll also have another PCC on the 11th. That will give you opportunity.
That answered my next question. That did answer my next question.
Okay.
Okay, because I
Okay.
just want opportunity, and I do object to the prosecutor using the pro se. I'm not pro se, I'm sui juris.
Sure.
Thank you.
However you want to say. Representing yourself, sui juris, pro se,
Myself,
On
I'm not
myself.
Civil War II, so I'm not a civil dead.
presenting
Sorry.
myself, all those things. They all mean the same thing. Okay. Thank you, everybody.
Okay, thanks.
Well, guys, we've come to the end of the proceeding of Mr. Robert Sigby. Definitely had a whole lot to say. Definitely had his sovereign citizen head on. I don't know if I heard anything that I haven't heard before. Maybe a couple things he mentioned sounded a little new to me, but for the most part, some of the same arguments that you hear from sovereign citizens. The judge, she definitely wasn't trying to allow the courtroom to get out of control. And as you remember, or maybe you don't remember, we was in her courtroom, I should say, about a week or two ago for the first time, and I saw then that she definitely is not trying to hear any type of nonsense or play any type of games or allow people to take over a courtroom. That is just not happening, and she didn't allow that to happen today. But I do agree that if the prosecutor's office, or I should say the police department, has more body cam footage that they can provide for Mr. Sigby, it definitely should be provided, just to give him a fair defense and possibly exonerate him from the way he's talking. So, we'll see what happens with this case. We see there is a continuance. There will be another probable cause hearing. We will try to follow up on that the best we can. And as always, I thank you guys for joining me here. Don't forget to like, comment, share, subscribe, all of the things that has made this channel great so far. With that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, Sovereign Citizens Court is adjourned. Thank you guys. See you guys soon. And God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.